be called to it. So if you were an alternate, you'd probably just throw out a cot and.
Lawyers like to hear themselves talk, don't they? My goodness.
What are you talking about?
So
There's
do
a
you-
question from the
go
chat that should just be addressed real quick because it was addressed in court if you missed it earlier. But they asked if the jury would have access to the videos to review. And apparently the law, at least in Wisconsin, is that if the jury is going to review video, they have to do it in the presence of the court. So they have to come out of the deliberation room, do it in the presence of the court, and then return to the deliberation room. Both the judge and ADA Krause disagreed and thought that the jury should have unfettered access to video. But when Krause requested some opinion on that, the opinion came back, I think from the DOJ, that would be reversible error to allow the jury unfettered access to video. So the answer to the question is the jury would have some access to review video, but that would be tempered by the court allowing them to review the video a limited number of times. And the worry would be that I guess the theoretical worry is that they would watch the same thing over and over and then maybe see something that isn't there eventually. Or I mean, that's the theory behind it, whether people agree or not. That's what the court determined.
We saw that happen in real time with the judge on the.
Yes, we did. We did see that happen, and that's the concern. Matt, what were you asking?
I was going to ask, are they going to be doing? I guess they would have to do that in open court. They bring them in, convene them, sit down, watch the video however many times they need to, and then they leave. I mean, that's kind of how we do it down here in Mississippi.
Yeah, that's what it sounded like from how they were describing it. So I would assume that it would be open to the public. Which is weird then, because does that mean that if the judge said he had a trial starting Monday, which is obviously going to get stayed, does that mean that they have to keep the trial room available, the courtroom available for the jury to deliberate over video? So does that mean it could push the other trial back significantly?
I would think so. Unless they've got an extra courtroom somewhere in the basement.
If you were defense counsel, would you want the jury to have unfettered access to the?
Hell no.
God, no.
Yeah,
not with the shit video evidence that they have.
Yeah.
Here's what's going to happen if they do. One juror is going to see what the prosecution says.
Yep.
And then they're going to watch it over and over with him doing the pointing thing and see. And then he'll convince people that the big blurry blob actually is a UFO.
Yeah.
Not to mention the fact that I missed this during the trial because of how the videos were introduced and the absolute trash foundational job that they did on every one of these videos. One of the videos has circles and it says Kyle possibly pointing his gun at Zeminski. It has hearsay testimony about what's happening. Wow. And that was allegedly introduced by the defense.
That's as admitted?
As admitted.
This is the worst defense ever.
And I don't actually remember the defense introducing that video because of, again, like how confusing the introduction of evidence was here. It's who are you? I'm a cop. I looked at videos online and I determined that they're real. And so here they are. Let me now testify to what happened in those videos is the most ludicrous thing I've maybe ever seen in my entire life. But that alone, but then, so apparently the defense introduced the video with the annotations. I don't know that we saw the annotations, but they're in evidence. They wouldn't be objecting to their own annotations anyway. And let's be honest, they wouldn't be objecting to the other party's annotations either.
They probably didn't even realize they had the annotations on there sometimes.
Well, that does happen.
I know we've talked a little bit about the ineffective assistance of counsel appeal and how hard that is, but the more and more I watch, the more and more I'm thinking, that's looking like a pretty plausible theory of appeal at this point, among others.
Well, if those are the defense annotations and they submit, that's ugly.
That could be a stipulation.
It's just one more thing on the
That's appealable error that's appealable. I'm saying as far as ineffective counsel.
Yeah.
Yeah, but that would be a collateral attack, wouldn't it? I mean, you'd have to go through all the appeals first and then do a PC.
Maybe I should just start writing the appeal. To give myself something productive to do.
So then Kyle would be in jail for a significant amount of time well before they
Yeah.
ever even get around to the issue.
Yep.
Well, and somebody famous like him is going to not have a great time in jail because either they put him on his own, so he's alone in there and going slowly crazy, or somebody takes a run at him is another possibility.
Yeah.
So I don't like that thought at all.
Me either. I'm very disheartened by what happened today. And again, it's not the state attorneys did not do a masterful job. The defense attorneys did
No.
a poor job, and that
Yeah.
To be fair, the state attorneys were more competent, have been most of the time. I mean, they diligently kept fighting, which is what you would expect them to do.
Yeah.
I think that they're liars. I think that they submitted evidence that they know is BS and made up some crazy narrative that I think that Krause actually believes has some sort of legitimacy. He started saying, well, when he's saying gun, 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 he's warning everyone about that Kyle's threatening them. Yeah, that's what happens. Someone fires off a gun in the air and a guy screams gun, gun, gun afterwards. He's probably talking about someone else as opposed to warning the crowd that, hey, there's been gunfire here. But that's what he's going to try and sell to the jury. And, we always feel like, let's try to read the jury. We have no idea what the hell the jury is thinking. We have no idea what they look like.
Nothing.
We don't know anything about them. We don't know what gender. We don't know there's no way to read a jury. We're not. If you're sitting in the courtroom, maybe you could read a jury, but none of us.
No, it's human beings all the way down. You never know what they're going to do.
Yeah.
And I think that's the problem with, you talk about ineffective assistance as an appeal route. I think that's true. But just talking about it on a more kind of platonic ideal basis, the problem with bad representation from the state, bad representation from the defense, is you're getting further and further from what anybody could logically describe as the truth of the situation as it happened on the ground. And it's become this kind of morass of screw ups from both sides. And that's the pity. I want the guilty to be punished, the innocent to go free. And we're so far afield from what the hell happened, because you've got all these stories coming from the state. You've got screw ups on the defense side with respect to objections. And, I wouldn't want to be on that jury sitting there right now, because you got a whole mess in front of you, and you've got instructions that aren't going to match up with necessarily what you even think you've been shown. And human beings are those human beings, and jury trials are a crapshoot.
It can be. With these instructions, certainly.
We know a motion to dismiss some of these charges has to come, because the judge is right. I keep saying has to. The judge is right there on the minor in possession charge. And if they can get that dismissed prior to jury deliberations, then they have to. If he's not illegally carrying, if the judge can come in and say, actually, we've dismissed that because he was not illegally carrying a gun at that point. It may be the thing that sways. One juror says, well, he shouldn't have been there illegally carrying. And they're like, I wish he wasn't there carrying a gun, but if it wasn't illegal, I mean, that could be the linchpin or the new one. I mean, oh God.
Within the instructions, there was no instruction that explained that even if he's illegally carrying a gun, that doesn't really weigh into the self-defense claim. Like there's no language like that. Like even if you find that he's illegal, that the gun was illegal, that he still has a claim of self-defense.
I think they can make the argument on it, but there's not a jury instruction on it.
Has Richards ever won a case?
A lot of people have asked. I think Barnes suggested he had not ever won at least a big case. But I don't know that, like I don't even know that Barnes actually suggested it. That's what I heard someone else say. This is hearsay testimony. Okay. This is hearsay.
Well, yeah. I actually heard Barnes say it.
Barnes.
I heard Barnes say something to that effect, but or something to the effect of people who have big wins go around talking about them a lot, and you never hear him talking about any of his past cases. So I think that was his speculation, as I recall it. Although me saying that to you is still hearsay. So
he's talking about his what? He's still talking about his iPhone logarithm, right? How did he miss
logarithm
versus algorithm? Yeah, like I have so many logarithms. The logarithm doesn't let me do it.
I'll give him a pass. That was the least of the problems.
Yeah.
Give him a pass.
Yeah, you can screw up logarithm all day.
Well, fellas, I have got to sign off for now because I have to go I've got to go pay the bills, and people are blowing my
Good
phone up,
good
wanting
luck
me to
with
send them
your
stuff. And
good luck with your cases.
Yeah,
Good
good luck.
That case.
Good luck.
Nice
Matt,
meeting
is,
you.
Yeah,
is there
nice meeting
anyone?
you.
Is there anyone who, or is there anywhere people can find you that I can put in the description of this video?
Well, my Twitter is @LawyerMatt. And
I will add you now.
I know you're getting added right this second.
And as far as YouTube, I have set up a channel. I just haven't posted my first video yet. I'm a newbie on this. I was about to start doing that maybe last week, get the equipment and that kind of stuff. And then I got hired on a very, very big case, and you know, I basically abandoned my family for about 3 or 4 days and worked just on that. And I still got to get ready for trial and lawyering stuff. That's right. So if I showed you my YouTube channel right this minute, it'd probably be embarrassing. But I emailed you the link, Nick, and if you want to see a nice picture of my Supreme Court admission picture, I mean, that's really about it right now. But subscribe, and maybe when stuff happens, we'll throw you stuff. So
you said you
Supreme Court admission papers. That'd be good.
You emailed that to me, Matt?
I did. I messaged you in response to your question earlier.
Okay, gotcha. I will add those both of those to the description.
And thank you for your hospitality, Nick. This has been a very, very good day. And I've enjoyed chatting with each one of you, and to the audience. I look forward to maybe coming back on other days, or if I'm invited, or barring that, if I have my own channel and y'all decide to watch, there you have it. So thank y'all very much, and
take care, Matt.
See y'all later.
See ya.
Thanks.
Bye.
Let me get
So I got a question from the chat.
Guys.
You gotta go.
Yeah, I gotta go pick up my kids. I'll see you guys a little later. I'll see you guys probably tomorrow. Well, not tomorrow, Monday or something. Take care, guys.
Yeah,
Nate, I'll see you Sunday. Oh, okay, bye. I got a question from the chat that I want to ask. Someone asked, wanted to know what the panel thought as to who would prefer pro se to this defense team.
No, I don't think so.
No,
I'll tell you, I would prefer state appointed counsel to Mark Richards.
I agree with that one. I agree with that one.
Well, I said in other places, I'm actually curious if they had just rested after the prosecution case, whether they'd be further. I don't know that they moved the ball very far on their side of the equation.
Yeah, they may have actually moved it back a little bit, to be honest.
Wait, what was that? Sorry.
Oh, just that I will never know, right? It's alternative universes, but I do find myself curious as to what would have happened if they stand up after the prosecution rests and say we rest as well. And go from there. I just don't think they moved the ball very much.
And we had such a great flavor at the end of the state closing their case, and we don't have that now. We didn't have that even yesterday when they said we rest. We didn't have that. So I've got to agree with you, Richard. They would have been better presenting zero defense at all than to do what they did for the last couple of days.
I mean, because they had everything they needed out of Gage Grosskreutz and Richie McGinnis. I mean that for the self-defense claims, you've got Richie McGinnis showing the Rosenbaum one. You've got Gage Grosskreutz getting Huber. I was scared for Kyle Rittenhouse because Anthony Huber was going to possibly cause head trauma with his skateboard. So you've got that. And then you've got him saying he didn't fire at you until you advanced on him, drew your gun, and pointed it at him. Right? Correct. I mean, open and shut on those things, in my opinion. The other things you have are the reckless endangerment charges, which I think are relatively ludicrous. We've got Jump Kick Man kicking him in the face on camera and him firing. I can't imagine. I can't even believe that they're charged. You're stomping someone's head into the ground on camera, and we're going to argue that they don't have a right to self-defense when people die from that on the regular. So anyway.
Yeah, I think the one thing though that I could see would be a reason for them to still put on some sort of a case in chief is the jury. The jury also, I mean, how many of them have ever been part of a trial before this time, right? Most people's perception of a trial is, for better or for worse, framed by what they see in movies and TV shows. So they may have had a concern over the idea that the jury would think, okay, if they're not putting anybody on, is that because they don't have any evidence? Is that because they don't have anybody on their side? So they may have been combating something like that. I don't know what you guys think about that possibility.
Well, there is still one.
Yeah.
There is still one more tactic the defense can use that would be analogous to of not putting on a defense, after the state had closed. The state could the defense could always waive their closing after Binger gets done with his first closing and cut off the rebuttal. And that sends the same kind of message. And frankly, would probably surprise Binger who's holding something back.
Yeah, that was.
Oh, go ahead. Did they call a ballistics or a firearms expert of any sort here?
I don't think so.
There was one. She was the lady who had the most insufferable cadence. She was there.
That was the prosecution expert, though. Yes.
Yeah, the defense didn't call anybody.
I completely zoned out her testimony, honestly, because of her cadence.
Yeah, she was a crime lab ballistics expert. Yeah, the defense should have had somebody because their argument. And again, the argument is being made, or the testimony is being offered by the prosecutors because they didn't properly object to the prosecutors arguing about the caliber of rounds and what they do. They correctly said Kyle's not an expert, but they didn't bring an expert. And John Black probably has the expertise to talk about it.
Also, if you bring a use of force expert, that could go a long way towards particularly establishing on the reckless endangerment that everything he did here was pretty much textbook as to what you would want a person to do in this situation.
Well, they had a use of force expert and they stipulated away his use of force testimony to get rid of Bob, which is a terrible
crazy
choice.
Yeah, and I just think there's all these arguments about over-penetration and about him possibly switching arms when he's wielding a sling, and I'm like, we need some evidence on this because it all goes for the defense if they actually know what they're talking about. And I'm worried that the defense they don't seem to have the background there, and they don't seem to have the knowledge that these are actually live issues. When the prosecution is talking about, these hollow point rounds, they explode. Well, the judge is sitting there going, no, but they needed actual evidence to say, listen, that's not a thing. And what does it actually mean that it's a full metal jacket round? 223 rounds often break up even if they are full metal jacket.
Yeah, they're designed to fragment and tumble. They're not actually designed for penetration. That's kind of the interesting thing. But in the judge today, though, he says, wasn't he using steel jacket rounds? Yeah. So the judge has an idea about the ballistics, and steel jacket isn't, steel versus a copper jacketed round might actually make a difference. I'm not an expert. I don't know. But again, this is going exactly to your point. Why didn't they have one? They have raised, I think, over $600,000 subsequent to the $2 million bail that they raised. They presumably have the funds to try this case with the best that you can offer, and they didn't.
I could have given them 40 names, and that's in the States. That's not even in my practice area, just of people that they could have called to say, hey, listen, these are. And I was kind of waiting for it, especially because there's so many arguments here. Somebody just sent me a message going, what about the fact that, it might be in his left hand? Well, wouldn't it be nice to have somebody who's actually used a sling on a rifle to say how much of a pain in the butt it would actually be to switch handedness when you've got it on a sling? How much time does it take to, get a rifle that is slung around your back? Because we see him carrying it in that fashion in some. How much time would this take? Would it actually be a one frame little moment, or would this be a more exaggerated gesture that you could see? All of these things I think could have been helpful. And everybody watches movies. Everybody sees, they watch John Wick and suddenly they think that they know guns. And the real danger is that you get police officers who do the same thing. They're like, I handle a gun all the time, therefore I'm an expert, and the court allows it. And lawyers who think that they know enough because they might have gone to the range a couple of times. I'm like, you don't know enough unless you've actually played around with ballistic gelatin, unless you've, or at least read the articles from people who have. Have you seen work done with witness boards to know about deflections? Have you, do you know what it means if the, like, do you know that different brands might actually behave differently and
different grain?
Oh, and bullets do weird things. I had a file where somebody was shot under the chin, and you'd never guess where the exit wound was.
His anus.
Elbow. Elbow. Because, and there's a case in the States where in a gas station robbery, they went and lined up people, shot them all in the back of the head. One of the survivors has an entry wound at the back of his head, an exit wound at the front, and it's because it hit his skull, tunneled under the flesh, and exited. All of these things you need people to be able to talk about when there's a reckless endangerment charge about what happens after you shoot through somebody. Mm-hmm. It's frustrating. And this isn't just a rant about this case. This is a rant about criminal practice in general.
But see, in a lot of criminal practice, you don't have $15,000 to pay that expert, right? But in this case, you do. That's the problem.
Yeah.
In this case, you have $50,000 to pay the best ballistics guy that you could possibly want. And
well, and it doesn't even necessarily start with the $15,000 conversation. It starts with reaching out, to somebody, even just the guy at the gun store is probably going to know more than your average lawyer, and just saying, "Can I have a chat with you?" When I had cases about lock picks, I didn't know a damn thing about them. So what I did is I called some locksmiths and said, "Hey, I'm a lawyer. You just want to chat with me for half an hour?" And it wasn't hard. There's lots of people out there who are entirely willing to have that conversation, and I don't think they did that. And it bothers me when I see these kinds of things and when I see case after case out there where you get these factual errors that creep in. I actually think that there should be sanctions potentially imposable. And I don't, it doesn't seem to be, when people go up and make representations to the court on technical points as if they know. As a lawyer, when they say, "Oh, it's just like a magnifying glass," if that turns out to be wrong, that should be sanctionable, because the lawyer's responsibility, if they don't know, should be to say, "I don't know."
Like their expert did.
Yeah.
Constantly.
And the state got to testify, basically. Anytime there were holes that they couldn't put anyone in the stand, they basically would testify, and the judge would be like, "Okay."
Yeah, I mean, the state's been testifying the whole time.
And Kyle turns out to be a legal expert, too, because he's correcting the prosecution on the law relative to firearms ID cards in Illinois and stuff like that. Yeah.
But see, I've been here short enough that I think I can say this. This is why I think that what you're doing here with the streams and the commentary is so useful. My show, Virtual Legality, focuses usually on tech and video games and that kind of thing. And I've been out there on Twitter with all the outlets talking about how dumb the judge is to not just accept that Apple Zoom In doesn't do anything to a photo. And you've got headline after headline after headline after headline after headline saying that, "Oh, this shows that the judge is biased," or whatever you want it to show if you're writing these articles. And it's such a normal course that the court has taken here to say, well, I don't have to take it on faith that it's a magnifying glass, that you doing this isn't something. And it's so funny to me because generally speaking, these outlets, hate Apple. They think they're doing all sorts of weird stuff behind the scenes. So I think it's super important to help explain to people that this is the highest level of power that the state generally uses against its citizenry, putting people in cages, potentially doing worse in different jurisdictions. And the court wants to get it right. And you could disagree with the defense or the prosecution or even the judge, but them slowing down and saying, "Hey, bring in some testimony to authenticate this," regardless of how you felt about that testimony, is not some ridiculous thing that's happening at the court level. It's exactly what you would want if you were being tried for murder. And I think this stuff, being able to look in on a case like this, is so useful because everyone else is not doing that.
Right. And the thing too is that I wish people would understand that anytime we're talking about technology, science, any kind of like complex theories of anything, courts are not just going to assume that they know anything. They are always going to bring it in through through valid experts. You know, there is such a thing as junk science. That's why we have certain standards that they have to meet in order to be introduced as evidence, because they have to be reliable in order for a jury to even look at it. So that's the thing, is that it has to be filtered through a process so that the jury can automatically trust it when it comes in front of them. And that's
Oh,
yeah.
sorry.
I was just finishing up.
He's ready to
in
go.
In an insurance claim case where you've got flooding in a house, they're not going to accept that you have 2.5 gallons per minute pipes based on the fact that basically everybody whose house is built after 1960 or something has 2.5 gallon per minute pipes. They're going to make you bring in a plumbing expert and talk about it. Because if you just try and offer testimony, well, how do you know that? Well, because I'm a lawyer and my house has it. Well, you have no idea. Like and so we're talking about interpolation of pixels on blowing up an image hundreds of percentage points. And the fact that they did not object immediately when the detective said, well, I used pinch to zoom on my iPhone and then I was able to see it, that they didn't object and say, Your Honor, are we serious here? We haven't reviewed the pinch to zoom. If he thinks he can see it, they can export it. They can explain how they exported it. They can present it to the court for review. This guy's just a cop with an iPhone, and he's going to testify that he saw Kyle Rittenhouse raise a gun because he pinched to zoom on his iPhone one time, and the jury doesn't get to see that. Just, oh, well, I saw it on my iPhone. Are you serious?
But we all have iPhones. We all have smartphones. We all know how they work. We're so used to them all the time.
Right. Yeah. I don't know how anything in my house works. It's good that it does, but I mean, we're lawyers, so the court doesn't assume anything, and yet it gets reported on, and obviously there's a narrative to go with all this stuff, but it gets reported on as how could the court block something as easy as you just zoom in and there it is. Gee whiz, we're pretty cautious about murder charges, guys. I would hope that you would want that for you.
I mean, you can argue that a screenshot of a tweet isn't authentic because it's been a manipulated image. And then they have to get on there and they have to prove that, as Joe has been hammering, it's a fair and accurate representation of the tweet. Right. And so, but you can then use that to try and cast doubt on the image all you want, but at least it'll get in because it's authentic. The crazy thing about this is we didn't have any testimony that the detectives made that any of the video was a fair and accurate representation of the video. He just said, I went to Twitter and YouTube and downloaded it. It's like, okay, what software? Did you download the whole file? Did anything get edited out? We have nothing. They should have objected.
YouTube never compresses anything in weird ways. That never happened.
Oh, geez.
And we still don't even know where the drone footage came from. And their foundation for it was played on Tucker Carlson. And then we got a copy. It's like, and the FBI drone footage, they apparently just decided to drop that. It seems like they stipulated to dropping that and striking his testimony from the record because they couldn't produce the HD footage. But again, they had that discussion in front of the jury. They already had the discussion about what was on the footage from the FBI guy. And it's like, object to this, object. They didn't produce this in a timely manner. It's prejudicial to your client. Object. I mean, and we don't know, to be fair, we don't know what objections were raised during that testimony, but based on history, I can assume none.
We haven't seen legal.
Bad it's been. I'm sorry, go ahead.
No, go. You.
I was just saying at this point, given how bad the defense has just effed this up in every possible way, if Kyle does not wind up in jail for the rest of his life, it's only because some deity somewhere really likes him and is casting his favor upon him. I cannot believe with this. I don't know if the court's coming back or not. And if not, maybe we can go and rewatch the moment where this all went to shit. But where they're letting in this instruction about provocation, the jury is going to get lost. If the prosecutor has any sense at all, they're going to get lost. And it's I'm back to all the black pills. Just it's all doom and gloom. I was so happy yesterday. How did I wind up here?
Right after the provocation moment, Kyle does the thing that that Kraus did a couple days prior.
Oh, that's good news.
He swaps it to doing his hair real quick. He realized he was face palming. Yeah,
But,
no,
He
I saw that
can
too,
face
though.
palm because there's no jury there, so he might as well face palm at this one.
No, I did see that too. You could see him go, "Oh no, I don't want this." He's media savvy there.
Real quick, Bat Gamer Show says the real Bat Store on eBay for your cakes and other special food. Over 700 plus item needs free shipping USA and international on all items. God bless everyone. And then
What am I going for
I
cake?
love when
'Cause
people use.
I could use a cake right about now. Where am I going to order this cake?
Apparently, the Bat Store the Bat Store on the real Bat Store on eBay seems like.
Okay.
Do you think that might be a Mr. Uncivil? You've worked in intellectual property. Is there a problem with having a store on eBay called the Real Bat Store and having a Batman logo as your logo?
If you have the Batman logo, yes, you have a trademark infringement problem.
How much modification of the Batman logo would be required?
All of it.
Well, enough that it would not be readily identifiable as the Batman logo would be super helpful.
615 base says this is one of two. Oh God, where's the other one?
I'm ordering cake.
Oh, I see it. I see it.
I'm ordering cake.
Says I think the most powerful moment was the tipping point in the trial when Backdoor Binger was bullying Kyle to tears, and Kyle kept saying, "I didn't want to do this." I think he was acquitted at that very moment. I would not be so fast on that one.
Yeah, I mean, if you've got LeBron on the jury, it's gonna play differently than it might to somebody else.
Yeah.
So, I mean, like that's a concern.
And if people aren't familiar, LeBron James was on Twitter basically calling Kyle a faker and various other things.
And he's not the only one. He's not the only one.
He's not just the most famous that I saw.
In fact, Michael Strahan interviewing Gage Grosskreutz asked the question in a very implied way how fake he thought those tears were.
A leading question. It was a leading question.
You could call it. Michael Strahan leads the league in footballs going through his teeth. 615 base says if you watch the live back at that point, you can even see big man Krause wiping his eyes like he was crying. Look, I'm going to quote Louis Anderson on Krause crying. Okay. He says, fat people sweat a lot. If fat people don't sweat, they explode. I'm not sure Krause was crying at that moment. I think he very well could have been wiping anything off of his face, like maybe a sweat bubble, because that guy gets worked up really quick. But he says he wiping his eyes like he was crying because he realized how screwed up the case was. I'm serious. You should go watch that point in the trial. I've seen the video of it. He might be crying. I don't know. It's impossible to say.
The thing is, though, is that if you weren't crying, and even if you were, you'd want to just grab onto the desk and just or just get up and go to the bathroom or something, because that's such a bad thing to do in front of a jury.
Michael Smith says, retired Army vet. I'm right-handed, so in order to use my left hand, I would need to remove the sling off my right shoulder and put it on my left shoulder. As far as sliding weapon around to your back, that takes mere seconds. No, you're right. If only they had someone experienced in AR-15 usage with slings that could have testified to it. If only they had John Black there, who has all sorts of weapons training and a 42-page CV on being a firearms instructor, could have maybe talked about that. If only they had done any of that, and not just given up his expert testimony at the Daubert hearing, we might have seen it.
Yep.
If you're going to give up him as a use of force expert, you got to hire someone else to handle some of these things, or just not bring Kyle to the stand, because all that all came up when Kyle was on the stand as well. But
it's almost like they couldn't see what was more than like 30 seconds ahead of them in the trial. That's really what it is. There's such lack of foresight, such lack of recognizing what was going to be coming down the road. This is really painful. This is really, really painful, because I'm like you, Kurt. I came into today thinking like this was an easy win. I was saying last night that a mistrial is a loss at this point, that we should be hoping for acquittals across the board, and that a mistrial hung jury is a loss. And now I'm sitting here thinking and that there was zero chance that 12 people would vote to acquit. And in the wake of today, I'm left thinking that there's at least a 25% chance he can get hit with a charge that will keep him in jail for several years, and that's very it's insane considering how all the testimony went. But that's just terrible lawyering.
Yeah, it's I'm trying not to be, super black pilled on it. We have to wait and see what happens, because
let's see how the arguments go. Because oral arguments I think will be important.
Like someone said earlier, I apologize for not remembering who. Maybe it was you, Joe. We don't know what the jury's reactions are to any of this. Actually,
yeah, that's true.
Well, I'm going to give it to someone else. Thanks, Hoglaw, for saying that. I really appreciate it.
Good job, Hoglaw.
What did I say? Oh, about juries?
Yeah.
That's true.
Yeah. I gotta step away for just a second, guys. I gotta go to the bathroom. I'll be right back.
So we're gonna do intros meanwhile, so everyone can know where to find us while you're doing that.
Yeah, absolutely. And all your links are in the description already. So yes, do some intros. I'll be right back.
All right, he really needs to go.
You can find me in the pit of despair.
You can find Kurt. He's in the pit
YouTube
of despair.
Yeah.
No, so why don't we start with you, Runkle? We'll go around.
So I post online as Runkle of the Bailey. I do criminal defense and firearms law up here in Canada. And yeah, a lot of my commentary is Canadian law, but it's weird. So I do have some Americans who follow and are sort of going, really? That's how it works up there? So you might be interested, you might not, but check me out.
Kurt, do it.
Yeah, I'm at Uncivil Law. I've got stuff on my channel that's interesting and exciting. Please check out the interesting and exciting things at Uncivil Law. What you got, Alita?
My name's Alita. I run the YouTube channel Legal Bites, where we explain the law one bite at a time. I'm on YouTube, Twitter, Instagram, Facebook, Locals, Patreon. You can find me on any of those. I am also doing a running challenge for every 5,000 subscribers I get. I'm adding a 5K onto the previous run. And this weekend I have to run a 10K and a 15K. So if you guys want to, well, they'll be on different days. So okay. It's fine. It'll be fine. But yeah, so that'll be fun. I'm doing that all the way up until 50K. And then after that, I'm not gonna do every 5,000.
130K.
I might do one for 100K.
And then after that, it's the Barkley, right? 50 is the Barkley.
Sure. I don't know.
Great.
Oh, glow.
You have no idea what you disagree to.
I don't actually. But yeah, what is the Barkley? If you're asking,
it's a bit of a challenging run.
Is it an ultra marathon?
Okay. Do you really want me to just tell you what it is flat out? Because it's okay. So the Barkley is this very famous run that occurs in Tennessee. It has a total elevation change of 50,000 feet over the course of about 100 miles, and it's through the woods. And it's unmarked, and you can't use GPS or anything, and it's all night and all day, and yeah, it's a thing.
That part doesn't sound so fun.
It's a total elevation change of 2 Mount Everest. So yeah,
wow.
Fun times by all. Yeah,
that's insane.
Over uneven ground in the woods near a prison. Fun.
Oh my gosh. Oh wow.
You can do it. I believe in you. I'll be there for your support.
So anyway,
So my name's Rick Hogue. I'm actually not a litigator. I'm a lowly corporate transactions guy doing mergers and acquisitions, venture capital, working on business stuff. And my show, Virtual Legality, on YouTube is focused on talking about important legal questions through the lens of pop culture. So we talk about Spider-Man moving between Disney and Sony. We talk a lot about video games, and my God, has video games as an industry been a lot of videos. We've covered all the Activision brouhaha. We've covered Epic versus Apple and Coalition for App Fairness. We just did a video for VentureBeat and GamesBeat talking about those specific issues in gaming and the iOS store. And you can find me on YouTube at Hogue Law and on Twitter, where with the voice as it is right now, I'm not making a lot of videos, but I am tweeting a lot. So that's really healthy.
And you also do
there. Yep.
You also do a collaboration with Colin Moriarty on Sacred Symbols, right?
Yes, I'm a contributor at Last Stand Media, so I'm there 3 or 4 times a month.
My husband is very jealous. He's a big fan of you, and he's a big fan of Colin Moriarty.
I'm gonna have to put that first part in there. I got what you were saying. He likes Colin. I understand. No.
He loves watching your content too.
Sure. Yeah, no, it's been a lot of fun. So yeah, you can find me at Last Stand a couple times a month, and definitely on my YouTube channel and Twitter.
I actually discovered your channel, Hoglaw, like a couple months ago, and I've been very impressed with your knowledge, your presentation, everything. You do really fine work there. So anyone hasn't checked you out,
fantastic! Thank you so much.
And you're always so fast. That's the biggest thing. Is like one of these days, I'm gonna get a video out faster than you, and I will feel like I have reached the apex of like YouTube. Like
this
YouTube
was the week
content.
I had to skip everything this week. I didn't realize how much I liked making videos until I didn't have a voice at all, and I was like, oh god, there's another one. There's another one. There's another one. So no, absolutely, that's very kind of you both to say. So thank you.
Yeah, so I'm Joe Neerman, also known as Good Logic. Really MAGA type of politics. I talk politics and law. I'm a New York litigator who now is a YouTube content provider, and as of this instance, I am the smallest channel in the land in this thing, and as of this instant, I'm at 9760, and I'm really trying to get to 10K.
Yeah,
so 10K is a big break, man. Go subscribe to Good Logic. It's a huge break for the channel, a huge break for my channel. It really helped me grow a lot. So go check out Good Logic. Subscribe right now.
Thank you, brother. I appreciate that.
He just commanded you to. You have to now.
So, yeah. So, are we gonna go through super chats, or is there more? Is there more coming? What's the story?
What the hell is this, Legal Bites? Not only do you and Kurt leave the stream, I see you on another stream watching my stream. What is this?
Yeah. Eric Huntley wanted to check in on how you guys were doing.
We were probably when that happened. We were probably in a pretty good mood.
Yeah, I think you were in a pretty good mood when that happened. Yeah.
That's pretty funny.
Oh my god. Yeah, I assume again. I've got the. I'll pull it up here. I've got the live stream. It's still active. I'm just waiting for them to actually bring it back to see. So,
Grosskreutz is also on CNN now.
Oh, good. Maybe we can tune into that and watch him live some more.
He's trying to clarify his statement.
I'm sure.
Oh, the one that the defense did not raise today, by the way, like that one, he's trying to clarify before the defense raises it that he said this thing yesterday, Judge. Maybe we should have bring him back in because he seemed to have lied under oath, according to his claim on Good Morning America. And I don't see that the defense brought that up. And I don't know that you want to, but maybe you do. But he clearly thinks he needs to.
By the way, I think Good Logic just made 10K.
Woohoo! Thank you guys.
See, we just demand it. We just demand it, and it happens.
That was
okay. Now I want 20,000 people who are currently subscribed to Nick.
20K
unsubscribe and subscribe to me.
Look, I just want an ice cream sandwich. That's all I want. I demand an ice cream sandwich.
Yeah. No, just
well, maybe if you get the hand from the heaven that Alita has, you will get an ice cream sandwich.
I forgot to mention I do stream nightly from Sunday to Thursday, 10 to midnight Eastern. I actually do a live stream that I end when Nick Rekieta starts his, because he's an hour behind me. So he always says I go from 11, that he goes from 11 to 2, but that's like broken Central Time. I'm going from 10 to midnight on Eastern Time, which is actually 11 Central Time. So a lot of people will watch me and then flip over to him, and so frequently you'll see me pop up on his show when he's talking about something that just annoys me or whatever. So
apparently Andrew Bronca, Law of Self-Defense, is saying that court is done for the day. I'm not sure why the PBS live stream is still running.
Andrew, if you're there, can you please hit me up?
It just now ends right when I say that. Okay.
Andrew Bronca, can you hit me up on Twitter, please, at Neerman Joe? Because I actually wanted to get you on.
He's not in here.